happiness, we've complied with them. And it got us talking, and I realized that we need to do a better job as a county of responding to these things, not only in terms of being more transparent, but being more efficient. And it's been really burdensome on staff, various departments responding to these PDRs, and we want to be open and transparent. I don't think there's anyone here who disagrees with that. So for me, the question is, how can we do that and not spend a lot of time doing it? And
money.
Time and money, thank you, Ms. Brenner. I want to be careful that we keep the focus looking at how we do better going forward and not who's making these requests, why they're making these requests. Let's just give everyone the benefit of the doubt and say, everyone's interested in open government, nobody's intentionally deleting emails. How can we keep better records going forward, and what are the rules so that we know as far as the open public meetings and retaining emails. So I have some ideas which we can get to later, maybe when we talk with legal staff and with Mark about ways we can do a better job of retaining emails and having discussions amongst ourselves via email without violating the law. Is there a presentation that we have? I was told by someone that we had a presentation. Mark, no? Okay. Okay, question and answer, great. All right, well then, can somebody please explain to us what the rules are exactly around Open Public Meetings Act and email discussions?
That sounds like a Karen question to me. And you need to state your name for the record.
First of all,
Karen, you need to state your name.
I'm sorry, it's Karen Frakes for the record. When I was told about this meeting, I thought it had to do with public records, not with open public meetings issues. And I know earlier when we met, Mark and I met with the council, or maybe it was just me, we did have a discussion, and we've had some discussions since then through emails about the parameters of where you can go with email communication. I don't want to get into a lot of detail here, but I think if I go back on my emails, I can find for you, all of you, and resend what I sent you before. There is in the material that Dana, I think, provided to you specifically. There's something from Steve DiGiulio which has a blurb on open public meetings, and basically when you start getting into a discussion about council business that involves more a quorum of the council, that becomes a public meeting and shouldn't be taking place. When you are just sending out informational material to the council and make it clear that it's just for informational purposes only, that you aren't trying to prompt a discussion, that's okay. But when you start discussing it with a quorum, whether it starts as a quorum or not, if it becomes a quorum, it becomes a public meeting, which requires the procedural notice, those sorts of things. So it's just sometimes better, I think, to avoid discussions like that via email, because what starts out as a discussion amongst two of you can very quickly grow into a larger discussion and bring up the issue of open public meetings.
Go ahead. I have a question on that. About a month ago, I sent an email to my fellow council members and the clerk stating that it was my observation that in the meeting prior to that, I had stated something about we can wrap this up next meeting. It was on a land use issue. And after I looked at the material, I immediately said, oh my word, there's way more than we're going to be able to do in one meeting. So I sent an email out polling the council members to see if there were expectations that we would conclude at the next meeting. Dana followed that up. She caught that and followed it up with, guys, you better not have any substantive discussion, but a direct response would probably be okay as to whether or not to continue the topic. I guess I'm wondering.
That's a meeting.
is, yeah.
Well, that's kind of, in fact,
other words,
Dana spoke to me about that
It
one.
wasn't substantive on the issue, it was about process.
Right.
And should we, I mean, since then, I've been gun shy to even talk about when we meet, it's
I know.
like, it's getting
Same
to the
here.
point.
Yeah, no, I was the one who told Dana that I thought it was okay if we just got responses from everybody but didn't engage in an active communication after that fact. So those are really hard calls to make, and I would appreciate it if you ever do have that situation come up again. Dana catches it most often, but if you want to consult with me before you do it, that's also a good idea, I think.
Can I ask another question kind of on that
Please.
train of thought? And this is going to go more into the public disclosure part. And maybe I'm just asking a rhetorical, philosophical question that doesn't need a response because you'll get it when I ask the question, and it is, had I picked up the phone and called council members individually, that's okay, right? I can call Ken and say, do you want to continue a meeting? But if I send an email, it seems not okay. And I'm trying to figure out the difference between what's going on there.
Well, there really isn't a difference as far as the open public meeting implications are concerned, and that's why I said it was okay to get a response to that procedural type question, because the same issues come up with discussions via telephone, conference calls, that sort of thing, as come up with emails. So, you do have to be careful about those type of chain discussions via the telephone too, because those can turn into open public meetings as well.
If he has 6 independent conversations regarding expanding a UGA, that can be in violation
Well,
too?
it can, especially, I could foresee somebody saying, the first person talking to the second person, and the second person saying, well, so-and-so said this, what do you think of this? And so it becomes a discussion without everybody actively participating at one time.
So it sounds like it's a question of intent. In other words, if we want to, if a less than public legislator wanted to just convince other people one at a time, if they're convincing a quorum, you still have the intent of trying to get a quorum decision, and that's what we need to avoid, is I think what you're saying.
Well, if it's one person just expressing their views to each person individually without a give and take, I don't see a problem with that. It's when you start getting the give and take, and that's passed on to other people in the process of talking to other people. It's a real fact-specific thing, and it's difficult to foresee every situation that's going to come up.
Okay, Councilman?
You want me to run the meeting or you want? I don't care. I love running meetings.
Yeah, go ahead. That's good. I'll be a participant.
Okay, great. Ms. Brenner.
Okay, thanks. Well, I think the best way to handle those kinds of things, sorry, Dana, is to ask Dana to check, and then it's a public record anyway. I don't understand why.
No, I don't think that solves your problem, because if it is an open public meeting, it needs to be noticed as an open public meeting.
Well, no, I'm talking about whether something is going to be put on an agenda or that's how we find out, is it gets sent out.
Yeah.
It's not something that it's just told to us. It's not something that we respond to.
Right.
How, you're getting me more confused here.
I'm not sure what you're asking. Not every communication you have is going to bring up open public meeting implications. Like if you call your fellow council meeting or members and say, I'm going to add something to the agenda, that's just an informational thing. You're not provoking discussion. That's not something that is subject to the open public meetings.
That's what I'm saying. That stuff goes through Dana usually.
Yeah, and I don't